Okay, guys, go to your search engine and punch in Texas Lawyers Creed. If you're in family court, civil court, or criminal court, you need to know what the Texas Lawyers Creed is. Why? Because it's a mandate for professionalism and it's the rules of engagement. What lawyers can and cannot do, what lawyers owe to the judicial system, what they owe to their client, what they owe to another lawyer, and what they owe to the judge. So let's dive in to the Texas Lawyers Creed. When it pulls up, you might see the Texas Supreme Court order of the Supreme Court of Texas and Court of Criminal Appeals mandate for professionalism. If you look to the right, it says the Texas Lawyers Creed, a mandate for professionalism. If you look to the left, it says order of the Supreme Court, and it is signed by all the justices of the Supreme Court and the Court of Criminal Appeals. Now, if you scroll down, you'll see, again, what we were talking about. What kind of professionalism is mandated to the legal system, lawyer to client, lawyer to lawyer, and lawyer to judge? So let's talk a little bit about the history of the Texas Lawyers Creed, because in 1989, this letter was sent by Justice Eugene A. Cook. And he says on November 7th, 1989, the Texas Supreme Court, or the Supreme Court of Texas, and the Court of Criminal Appeals adopted the Texas Lawyers Creed, a mandate for professionalism. Those who know about Rambo in the 80s, in 89, I was 9. I was all about Rambo and the action movies that Rambo made or Sylvester Stallone made. But those who believe that waging Rambo style litigation is the way to practice law do a tremendous disservice to our entire profession. Lawyers with this type of attitude, instead of being part of the solution, have become part of the problem. Lawyers want to restore civility to the courtroom, to the discovery process, and to the entire practice of law. And it goes on to say, with each of us making a daily commitment to our profession, we can defeat Rambo, restore public confidence in our profession, have fun practicing law, faithfully serve our clients, and fulfill our responsibility to the legal system. Very truly yours, Eugene A. Cook, Justice. There's even some pages that make it aesthetically pleasing to the eye by putting these colorful brochures. This brochure is from the Texas Bar Foundation, and it's the same thing, except it doesn't have the signatures. This isn't, and again, it says order of the Supreme Court of Texas and the Court of Criminal Appeals. Is it enforceable? I don't know. I'm going through that rabbit hole right now, and when I find out, I'll update you guys with my findings. Again, here's another version of the Texas Lawyers Creed. And again, you can find them all over. Some of the Texas area law schools have them on their website, although they don't really teach them. And that's another story. If you go to the Texas State Bar Foundation website, and here's the link above, you're going to see the Texas Lawyers Creed, and you're probably going to see this page. And let me just read the Texas Lawyers Creed, a mandate for professionalism. I am a lawyer. I'm not a lawyer. It's just what I'm reading. I don't want to say I'm a lawyer and then someone tried to hit me with felony charges for practicing. I'm not an attorney. This isn't legal advice. I'm just telling you where to look. I can read and I can comprehend and I can put two and two together. I am a lawyer. I am entrusted by the people of Texas to preserve and improve our legal system. Man, this shit sounds great. I'm licensed by the Supreme Court of Texas, and therefore I must abide by the disciplinary rules of professional conduct, but I know that professionalism requires more than merely avoiding the violations of the laws and rules. I am committed to this creed for no other reason than it is right. So you go to the mandate for professionalism to the legal system. I am passionate and proud of my profession. Therefore, my word is my bond. And again, I'm not going to go through the whole list. I'm just going to hit certain portions. Your job is to go and look for this and then see how you can use it within your case. Lawyer to client. A lawyer owes a client allegiance, learning, skill, and industry. A lawyer shall employ all appropriate legal means to protect and advance the client's legitimate rights, claims, and objectives. Again, let's read that again. Protect and advance the client's legitimate rights, claims, and objectives. A lawyer shall not be deterred by any real or imagined fear of the judicial disfavor of public unpopularity, nor be influenced by a mere self-interest. Now, Do some of these family lawyers have any self interest? Absolutely, they do. Let's dive into lawyer to client. Going over lawyer to client rules 6, 7, and 9, I'm going to read them to you and tell me if these sound familiar. I will treat adverse parties and witnesses with fairness and due consideration. A client has no right to demand that I abuse anyone or indulge in any offensive conduct. Number 7, I will advise my client that we will not pursue conduct which is intended to primarily to harass or drain the financial resources of the opposing party. Now, let's get into number 9. I will advise my client that we will not pursue any course of action which is without merit. Now, we know that we have a lot of attorneys that are using protective orders to gain the advantageous results in family court. And so this is where I have an issue with the mandate for professionalism. While there's something that's signed by Supreme Court justices and justices of the Court of Criminal Appeals, a lot of there's no admonishment for this type of bad behavior. While it's written and it sounds great, the legal system doesn't really uphold this. And that's what I'm trying to do. I'm trying to educate others that are in the public that are pro se or don't know their rights to start bringing up these issues. Again, the Supreme Court in 1989 saw that civility was being lost in our courtrooms. So they mandated this order for professionalism. And these are the rules. When you get into lawyer to lawyer, number 1, I will be courteous, civil, and prompt in oral and written communications. Those that have seen some of my case have seen where opposing counsel Carolyn Robertson, board certified attorney lawyer Carolyn Robertson, went to the University of Houston. And when you go and you look back at the Texas Lawyers Creed, one of the first one that pops up is University of Houston Law Center, Texas Lawyers Creed. She definitely doesn't know the Texas Lawyers Creed. And I've brought it up in court that she's not abiding by it. But you're going to get some lawyers say, well, you're not a lawyer. This says lawyer to lawyer. It doesn't say lawyer to pro se litigant. But my defense to that is that when I go to court, they always tell me, Mr. Saldana, if you're going to participate in this court as a pro se litigant, I have to treat you like a lawyer. You better know the rules. You better know the laws if you expect to conduct business in our court. That's how I'm talked to. So I would think that lawyer to lawyer would also mean lawyer to pro se litigant because I'm my own lawyer. Number 13, I will not attempt to gain the unfair advantage by sending the court or its staff correspondence or copies of correspondence. Now, if some of y'all have been following my case, you know that board certified 30-year attorney Carolyn Robertson sent all of the emails that I sent to her to the judge. And she didn't even share it with me. So I believe that's ex parte communication. But what are these rules for, right? Lawyer to judge, the mandate for professionalism between a lawyer and a judge. Lawyers and judges owe each other respect, diligence, candor, punctuality, and the protection from unjust and improper criticism and attack. I will treat counsel and opposing parties of the court and members of the court staff with courtesy and civility. I will be punctual. Again, some of y'all know that attorney, opposing counsel, attorney, board certified of 30 years, Carolyn Robertson from the University of Houston wasn't punctual. She was 2 hours late. I drove from San Antonio to Houston. I was on time. She wasn't. She wasn't prepared. I asked for a default, but again, I'm pro se. What do I know? The second one, I will not engage in any conduct which offends the dignity and decorum of the proceedings. I will not knowingly misrepresent, mischaracterize, misquote, or miscite facts or authorities to gain an advantage. This one is a big one that is used in family court. We know that lawyers are misrepresenting, mischaracterizing, misquoting, and misciting facts to gain the advantageous results. So that's why I say the Texas Lawyers Creed is a great outline for you to start, so that you know that what the rules of engagement are when you walk into a family court, a civil court, or a criminal court. Again, this is the Texas Lawyers Creed, a mandate a mandated order for professionalism from the Supreme Court and the Court of Criminal Appeals. Again, this is not the disciplinary rules of professional conduct. That will be a video I will be doing later to discuss. But if you're going into family court, civil court, or criminal court, please know the rules of engagement, and it all starts with the Texas Lawyers Creed. Tell me what you think in the comments below.